Welcome. You're joining us for a systematic exploration of some very sensitive and deeply complex source material.
Hmm.
Our focus today is on the tragic events surrounding the arrest and murder of George Floyd in Minneapolis, Minnesota on May 25, 2020.
This is a demanding subject, and we're approaching it with, a full recognition of the gravity of the loss and the societal shock it caused.
That's right.
Our goal here is to really extract the critical knowledge from the extensive documentation, the precise timeline, the layered legal proceedings, and the systemic impact to give you a thorough, impartial understanding of the facts supplied in this material.
The narrative really begins with the man whose life was lost, George Floyd. The sources describe him as a 46-year-old Black American man.
He was originally from Fayetteville, North Carolina, and had grown up in Houston's 3rd Ward.
And then in 2014, he relocated to the Minneapolis area, eventually living in St. Louis Park.
There's one detail, and it's often overlooked, but it's critical for context, and that concerns his employment. Floyd worked various jobs, including security shifts at a local nightclub. The documentation notes, and it's quite chilling, that Derek Chauvin also worked security shifts at that same place.
The officer who?
Yes, the officer who ultimately knelt on his neck. Now, the extent of any prior personal relationship between them, that was never definitively confirmed.
So let's break down the 4 individuals who were officers that evening. All of them were dismissed from the Minneapolis Police Department the very next day. We should start with the primary figure, Derek Michael Chauvin.
Chauvin was 44 years old, a white American, and a significant veteran of the MPD. He'd served for 19 years, since 2001.
19 years.
Yes. And when he arrived on the scene, he immediately assumed command. He was the one responsible for applying that fatal restraint, kneeling on Floyd's neck.
And that experience level, that becomes a critical factor later on, doesn't it?
It does, especially in his sentencing. The fact that he was so experienced and his failure to train or guide the junior officers, that was a huge part of the legal argument.
Then we have Tu Thao. He was a 34-year-old Hmong American officer.
Thao's career path was a bit different. He started as a community service officer in 2008, took a 2-year break, and then resumed full police duties in 2012.
And his background, the records showed some red flags that came up during the investigation.
They did. The records show 6 prior complaints had been filed against him. None of them resulted in formal disciplinary action. But the most specific detail, it involves a 2014 excessive force lawsuit.
And that lawsuit is a key indicator of systemic issues, isn't it? Can you elaborate on what exactly that prior incident involved?
Absolutely. The man who sued alleged that Thao handcuffed him without probable cause, violently threw him to the ground, and then subjected him to punching, kicking, and knee strikes.
So he required hospitalization.
He did. He had broken teeth. The city of Minneapolis actually settled that lawsuit for $25,000. It confirmed the severity of the allegations, even without an admission of guilt.
And during the Floyd incident, his role was what exactly?
Strictly crowd control. Just standing guard and actively preventing bystanders from intervening or offering any aid. His prior history really bolstered the prosecution's argument that he was a seasoned officer who knew he was abusing his authority.
Which made his later claim of ignorance.
Very difficult to believe.
That brings us to the 2 most junior officers, J. Alexander Kuhn and Thomas Kiernan Lane. Kuhn was 26, a Black American, and Lane was 37, a white American.
And what makes their situation so relevant is their stunning lack of field experience.
They were rookies.
In the purest sense of the word. They had only been licensed in August 2019. This means they were both, staggeringly, in their very first week as official MPD police officers when they arrived at Cup Foods.
Their first week?
Yes. And the documentation highlights that Chauvin was specifically assigned as Kuhn's field training officer. So you have this very distinct superior-subordinate dynamic.
A dynamic their defense attorneys would later lean on heavily.
They did, arguing that they just deferred to the veteran officer's judgment.
And the sources point to an immediate precursor incident involving these 3, Chauvin, Kuhn, and Lane, just weeks earlier, May 3rd, 2020. That seems highly significant.
It's deeply troubling. It completely eliminated any reasonable claim that they were unaware of the dangers of a prone restraint.
So what happened in that incident?
Video evidence from that earlier event showed these same 3 officers roughly detaining another man on the ground. And crucially, that individual also complained of severe difficulty breathing under their restraint.
Mirroring the exact
fatal situation that would unfold 3 weeks later with George Floyd. This detail just seriously undermined any later defense arguments about a lack of training on positional asphyxia.
I also want to circle back to Thomas Lane, The materials revealed some details about his application history. Parts of his criminal record were redacted.
Yes. Convictions for obstructing legal process and damaging property when he was 18.
Wait, so Lane had a history of obstructing legal process, and that was redacted on his application to become a police officer.
It was. And that fact became a major point for the prosecution regarding the MPD's vetting procedures.
I can imagine.
I mean, how does a department hire someone whose record shows a prior failure to comply with the legal process when that person is expected to enforce it?
So the prosecution argued it was a systemic failure.
Exactly. A failure in both vetting and training, creating an environment where inexperience and, questionable past conduct were allowed on the street. It weakened the defense's ability to just claim Lane was a clean slate rookie.
So what we have is a mix of an established veteran with a history of excessive force lawsuits, a senior officer actively preventing aid, and two novices operating under the direct command of that veteran.
Mm-hmm. And understanding those prior contexts, the command structure, the history of excessive force, it's the foundation for analyzing the legal concept of willfulness that defined the federal charges later on.
Let's move to the evening of May 25, 2020. The events began just before 8:00 p.m. at Cup Foods. George Floyd used a suspected counterfeit $20 bill to buy cigarettes.
When the employees realized the bill might be fake, they immediately approached Floyd, who was in his SUV nearby, and they demanded he return the cigarettes. He refused.
And an employee then called 911.
Yes.
What's important here is what the employee told the dispatcher. They reported fake bills, but added that Floyd was awfully drunk and not in control of himself.
And that narrative of intoxication, that became the initial frame for the police response. It set the expectation for a situation involving a disorderly person, not a minor financial crime.
Right.
The store owner later said that, often patrons don't even realize they've passed a fake bill. The typical procedure was just to ensure no further crime was committed, not to escalate it.
So the question becomes whether a violent response was justified over a minor forgery allegation.
Precisely. A typically non-violent offense.
Kung and Lane were the first to arrive at 8:08 p.m., and the encounter escalated almost instantly.
It did. Lane approached Floyd's SUV, tapped his flashlight on the window, which startled Floyd, and he immediately drew his gun, ordering Floyd to show his hands.
So a gun was drawn right at the start.
It was. Though Lane holstered it once Floyd complied, the drawing of the gun established an immediate high-tension atmosphere. After a brief struggle, they pulled Floyd from the SUV and handcuffed him.
This is where the records showed the first signs of physical distress and the beginning of that crucial dialogue.
Floyd was observed with foam around his mouth, and when they asked him about it, he said he had been hooping earlier.
A term that became ambiguous during the trials.
Yes. It could mean recreational basketball, or, as the defense argued, drug use, but he expressed profound fear.
He was visibly distressed.
Very. And when they tried to move him into the patrol car around 8:13 p.m., his claustrophobia became apparent. He started pleading, stating clearly that he couldn't breathe, that he had anxiety.
He also mentioned he was recovering from COVID-19.
Yes. And he offered them an alternative. He said, "I'll lie on the ground rather than get in the car," which showed a willingness to comply without entering that enclosed space.
His offer to lie on the ground is such a haunting detail given what happened next.
It is.
And the situation fundamentally changed with the arrival of the backup officers.
Yes. Chauvin and Thao arrived at 8:17 p.m., and Chauvin immediately took charge. The attempts to force Floyd into the car continued, despite his protests. The record shows him repeating, "I can't freaking breathe," twice more, even before the fatal restraint began.
At 8:19 p.m., the scene shifted to the pavement. Chauvin pulled Floyd across the back seat, and Floyd exited the vehicle, falling face down on the ground.
And the next 9 minutes. These were the focus of all the state and federal proceedings. They were captured on video and meticulously detailed in the sources.
The restraint details are the core of the state's murder case.
Floyd was handcuffed, prone, lying on his chest. Chauvin applied his knee directly to the back of Floyd's neck,
while Kung placed significant pressure on his torso.
and then Lane restrained the legs. Thao formed a barrier against the developing crowd. The prosecution argued this four-way compression effectively suffocated him.
Mechanical and positional asphyxia. Floyd stopped struggling physically around 8:20 p.m., though he was still conscious and speaking. This is the period of the relentless, "Please, I can't breathe, please," and that desperate call for his mother.
The documentation reveals the intensity. He said, "I can't breathe," at least 16 times during this period.
And Officer Lane, the rookie, he recognized the danger.
He did. He requested an ambulance. noting that Floyd was bleeding from the mouth, which signaled his belief that medical aid was necessary.
This is a critical point that the prosecution must have hammered home. The most junior officer recognized the danger and requested aid. But what was the response from Chauvin, the veteran in charge?
One of callous indifference. When Floyd, in obvious agony, said, "I'm about to die," Chauvin dismissed him, told him simply to relax.
That level of active dismissal was central to the sentencing, the particular cruelty finding.
It was, and the crowd of bystanders was escalating their intervention. They could see that Floyd was visibly deteriorating.
And Thau's role during this, he wasn't physically restraining Floyd, but he was essential to maintaining the situation.
He was the critical buffer. He actively prevented witnesses, and some of them were trained medics, from approaching.
When a witness voiced concern that Floyd couldn't breathe, what did Thau say?
He countered by saying, "He's talking, he's fine," trying to create this false sense of security.
And in one particularly cruel moment, detailed in the records,
He used the situation to lecture the distressed crowd, saying, "This is why you don't do drugs, kids." This act of obstruction and this attempt to frame the dying man as the problem that defined his role in the failure to provide care.
by 8:25 p.m., Floyd's voice faded entirely. He appeared unconscious. This is when the question of medical care became one of life and death.
The records show bystanders urging the officers to check Floyd's pulse. Kong finally checked his wrist and reported to his senior officers that he found no pulse.
No pulse. And yet, despite that confirmation,
Despite confirmation of a medical emergency, the officers made no attempt to provide basic life support. No CPR on the ground. This failure became the primary evidence in the federal trial.
and this brings us back to Lane, the officer who already called the ambulance. He asked Chauvin if they should reposition Floyd. He asked this twice, right?
That detail is absolutely damning for Chauvin. Lane asked him not once, but twice, if they should roll Floyd onto his side, a common procedure to prevent positional asphyxia.
And Chauvin explicitly rejected the suggestion both times.
Both times. The criminal complaint later emphasized that officers are specifically trained that applying a neck restraint with a subject in a prone position is inherently dangerous. By ignoring both his junior officer's concern and his basic training, Chauvin cemented the foundation of the state's murder case.
Let's transition now, moving from the street to the medical and legal aftermath. Let's cover the medical response and the official findings of death, which define the trials.
The slow response to a known medical emergency is a significant focus of the source material.
They called a non-emergency ambulance at first.
They did, at 8:22 p.m., only upgrading the call to emergency a minute later. Precious time was lost.
The ambulance finally arrived at 8:27 p.m. And what is perhaps the most shocking aspect of this timeline is that Chauvin kept his knee on Floyd's neck.
For almost a full minute after the paramedics were already on the scene.
It demonstrates a willful continuation of force.
Absolutely. The paramedics quickly got Floyd onto a stretcher. Lane, the rookie, was told to ride along in the ambulance. A medic immediately instructed him to perform CPR after checking the pulse at the neck, confirming the absolute critical nature of the situation.
At the same time, the Minneapolis Fire Department, the MFD, had been called. They arrived at Cup Foods at 8:32 p.m., but their report noted a crucial delay.
It did. The police officers on site provided no clear information about Floyd's condition or the location of the ambulance, so it hindered the MFD's ability to find and assist the transport team right away.
MFD medics eventually caught up with the ambulance
And confirmed Floyd was unresponsive and pulseless. Despite all these frantic efforts, he was pronounced dead at 9:25 p.m. at Hennepin County Medical Center.
Immediately following this, the police attempted to control the public narrative.
An MPD statement issued early on May 26 was fundamentally misleading. It claimed Floyd physically resisted officers and then appeared to be suffering medical distress.
With no mention of the knee on his neck?
None at all. But that narrative collapsed almost instantly. The public release and rapid circulation of witness and security camera videos forced the department's hand
Only then did they update their statement.
and announced the immediate termination of all 4 officers. It just highlights the crucial role of that citizen footage.
The autopsies then generated intense legal focus. They all confirmed the death was a homicide, but with slightly different phrasing.
Which the defense later tried to exploit. The official autopsy was done by the Hennepin County medical examiner, Andrew Baker. His report determined the death was a homicide caused by cardiopulmonary arrest, complicating law enforcement subdual, restraint, and neck compression.
But the defense seized on the secondary findings in that report.
Exactly. Baker noted several significant co-conditions:
Yeah.
severe pre-existing heart disease, an enlarged heart, severely narrowed arteries.
And the presence of fentanyl and recent methamphetamine use.
Correct. Suggesting these factors may have increased the likelihood of death. The defense's entire strategy rested on muddying the waters, claiming these health issues were the true cause.
But the family-commissioned autopsy directly countered that strategy.
It did. Performed by pathologists Michael Baden and Alicia Wilson, they stated the death was an undeniable homicide caused by asphyxia due to sustained neck and back compression.
Their key finding.
They explicitly concluded that Floyd died at the scene and found no underlying medical problem that contributed to his death. They stressed that the ability to speak doesn't mean you can breathe, especially when compressed.
And the federal review solidified the findings.
Yes, the Department of Justice requested a review by the Armed Forces Medical Examiner. That review supported the Hennepin County findings, but added that the restraint involved elements of positional and mechanical asphyxiation. So the consensus across all three reviews was clear. The police restraint caused the death.
That forensic evidence leads us directly into the legal decisions. So let's look at the early investigations and that pivotal choice that guaranteed a lengthy legal battle.
Federal involvement began immediately, which established that dual accountability track. The FBI announced its review on May 26, and the DOJ quickly designated the case a top priority.
There was an interesting moment on May 28. A press conference was expected, but it was delayed. It was later revealed Chauvin was trying to broker a plea deal.
This is one of the most significant political interventions in the entire case. The sources revealed that Chauvin was willing to plead guilty to third-degree murder for a 10-year prison sentence.
And this deal would have covered both state and federal charges.
It would have, offering the state a guaranteed conviction without the risk of trial.
But U.S. Attorney General William Barr rejected it. So the political pressure of the moment fundamentally shifted the entire legal strategy.
Precisely. Barr was concerned, and the documentation confirms this, that a 10-year sentence would be perceived by the massive wave of global protesters as far too lenient. The political consensus was that justice needed to be seen through a full legal process.
So state charges followed swiftly on May 29. Chauvin was initially charged with third-degree murder and second-degree manslaughter.
It was a strategic choice, but limited. Third-degree murder in Minnesota only requires a depraved mind or reckless action, not a specific intent to kill. The prosecution knew they needed a stronger charge.
That upgrade came on June 3. The charge was changed to second-degree murder, and the other three officers were charged with aiding and abetting.
The shift to second-degree murder was crucial because it targeted unintentional felony murder, meaning the state argued Chauvin committed a felony assault that resulted in death, even if he didn't intend to kill George Floyd.
Which strengthened their case significantly.
It did. It allowed them to avoid proving specific intent.
Following the charges, all four officers eventually posted bail and were released, with Chauvin last, on a $1 million bond in October 2020.
And that release period allowed time for the immediate societal response to solidify. And that response wasn't just protests, it triggered immediate institutional action.
Like the Minnesota Department of Human Rights opening a sweeping civil rights investigation into the MPD.
Yes. And the Minneapolis City Council responded almost instantly on June 5 by banning chokeholds and neck restraints.
And implementing a policy requiring officers to intervene against colleagues using excessive force.
A policy directly targeting the inaction of Kung, Lane, and Thao.
Now we enter the complex trial phase, beginning with the state conviction of Derek Chauvin. This was the highly anticipated trial, Minnesota versus Chauvin.
The trial began in March 2021 and was, scrutinized globally. The prosecution presented an overwhelming case built on video evidence, police training manuals, and expert testimony showing clear policy violations.
The jury returned its verdict on April 20th, 2021. Chauvin was found guilty on all three charges.
Second-degree unintentional murder, third-degree murder, and second-degree manslaughter.
The historical significance of this.
It cannot be overstated. He was the first white police officer in Minnesota ever convicted of murdering a black person. It was a massive, immediate validation of the prosecution's strategy.
The sentencing, delivered by Judge Peter Cahill on June 25, 2021, was another landmark moment. 22.5 years. That's more than the state's guideline of 12.5 years.
The reason for the enhanced sentence is crucial. Judge Cahill found that Chauvin committed 4 aggravating factors, most importantly determining that he treated Floyd with particular cruelty.
And that finding stemmed directly from the 9 minutes of indifference.
Exactly. The continued restraint after Floyd lost consciousness, the rejection of pleas, the failure to provide basic aid, all of it.
The sources show Chauvin immediately began the appeal process.
Yes, the Minnesota Court of Appeals affirmed the conviction in April 2023. His subsequent petitions were then rejected by both the Minnesota Supreme Court and finally the U.S. Supreme Court, solidifying the state verdict.
But we also have to trace the parallel federal prosecution track against Chauvin.
Right, the dual accountability theme. In May 2021, he was indicted on federal charges for violating Floyd's civil rights, unreasonable force, and deliberate indifference to medical needs.
He initially contested these, but in December 2021, he pleaded guilty.
A pragmatic legal move. By pleading guilty, he guaranteed the sentence would run concurrently with the state sentence. No additional time.
But he had to officially admit.
He had to admit that he willfully violated Floyd's constitutional rights, a standard higher than the state murder charge. It was a formal acknowledgement of both the unreasonable force and the deliberate indifference.
His federal sentence was handed down in July 2022, 21 years.
Served concurrently with his state sentence, which meant a total incarceration of roughly 17 years. It's a key example of how the federal system can layer accountability onto state findings.
This complex, dual-track prosecution of Chauvin really set the precedent for how the three junior officers would also be held accountable.
Which brings us to the unique challenges of their legal paths.
Let's look at the federal civil rights trial for Kung, Lane, and Thao, which began in January 2022. This trial focused specifically on their failure to intervene and provide aid.
An interesting contrast from Chauvin's state trial was the jury composition. It appeared to be all white, which was different from the more racially diverse jury that convicted Chauvin, but the evidence was insurmountable.
The testimony here centered on training and neglect.
Absolutely. The defense tried to argue ignorance and inexperience, but key testimony from a police trainer confirmed that officers are explicitly trained to move a subject onto their side to prevent cardiac arrest.
Which undermined their claim that they didn't know the proper procedure.
It established the element of deliberate indifference.
And the medical testimony was incredibly strong.
Dr. David Sistrom, a pulmonologist, offered a staggering insight. He testified that if the officers had simply performed CPR on Floyd, his chances of survival could have doubled or tripled.
That really crystallizes the difference between passive neglect and actionable criminal indifference.
It does. It focused the jury squarely on the 8 minutes of lost opportunity after the pulse was confirmed lost.
Thao's testimony was central here.
He claimed he was focused on crowd control, was unaware of Floyd's critical state, and asserted that the prone restraint was not uncommon. His defense was basically ignorance.
Despite that, the jury delivered a swift and unified verdict on February 24, 2022.
All three were found guilty on all federal counts.
The specific convictions were critical.
All three were found guilty of willfully failing to provide medical care. Kung and Thao got an additional guilty verdict for failing to intervene against Chauvin's unreasonable use of force.
Federal sentencing occurred in July 2022. Lane got 2.5 years, Kung 3, and Thao 3.5.
The varying sentences clearly reflected their degrees of culpability. Lane, who expressed concern and called for an ambulance, received the lowest. Thao, who actively managed the crowd and prevented intervention, received the highest.
The three officers then faced separate state criminal proceedings.
And they each took distinct legal paths. Thomas Lane resolved his case first. In May 2022, he pleaded guilty to aiding and abetting second-degree manslaughter.
So the murder charge was dropped. And his sentence.
3 years, concurrent with his federal sentence, so no extra time. But critically, the plea required him to formally admit that he knew the restraint created a risk of death and that he heard Floyd say he couldn't breathe.
He was the first to publicly admit guilt.
Yes. He was eventually released in August 2024.
And J. Alexander Kung followed a similar path.
He pleaded guilty to aiding and abetting manslaughter in October 2022, right before his jury selection was set to begin. He was sentenced to 3.5 years, also concurrent, and was released in January 2025.
Thao, however, took a significantly different and riskier approach.
He refused a plea deal. On the same day Kung pleaded guilty, Thao waived his right to a jury trial. He opted for an evidentiary trial, where Judge Cahill reviewed the stipulated evidence.
So a trial based solely on the records, videos, and prior testimony. The prosecution argued he actively encouraged the restraint. The defense maintained his role was just crowd control.
Judge Cahill delivered his verdict in May 2023, finding Thao guilty. His written analysis was meticulous. He ruled that Thao actively encouraged his three colleagues' dangerous prone restraint and was fully aware Floyd had become unresponsive.
He was the last of the four to be sentenced in state court. He received the maximum 4 3/4 years.
Again, concurrent with his federal time. Judge Cahill took the opportunity to clearly define the culpability hierarchy. He said Thao was less culpable than Chauvin, but unequivocally more culpable than Lane and Kwon.
Reviewing these complex, separate legal paths reveals an extraordinary achievement. All 4 officers were successfully prosecuted, convicted, and sentenced on both state and federal charges.
It truly established an extraordinary legal precedent, not just holding the primary actor responsible for murder, but holding the assisting officers accountable for their constitutional failure to intervene and render aid.
Finally, we have to examine the immense broader aftermath and the institutional reviews that followed, starting with the civil settlement.
In a major legal milestone, on March 12, 2021, the city of Minneapolis settled a wrongful death lawsuit with Floyd's family for $27 million.
At the time, that was the largest pretrial civil rights wrongful death settlement in U.S. history.
A profound admission of the city's liability.
It's important to note how that settlement was allocated.
Yes. A significant $500,000 portion was earmarked specifically for the community around the intersection of 38th and Chicago Avenue, the site of the murder.
A commitment to restorative justice.
Mm-hmm.
Beyond the courtroom, the societal reaction was on a historic scale. George Floyd's murder sparked a worldwide protest movement.
It was the largest wave of protests in the United States since the civil rights movement of the 1960s. Demonstrations supporting Black Lives Matter erupted in over 2,000 U.S. cities and dozens of nations internationally.
And the details of the restraint created specific, powerful symbols.
The phrase, "I can't breathe," Floyd's final plea, became a universal rallying cry. And the length of the restraint, 8 minutes and 46 seconds, became this widely adopted symbol for moments of silence.
While most demonstrations were peaceful, the sources do acknowledge significant civic unrest, especially in the Twin Cities.
The 3rd Precinct Police Station in Minneapolis was evacuated and set on fire. The documentation cites over 1,500 businesses in the area that were vandalized or destroyed. It was severe enough that curfews were imposed across 200 U.S. cities.
And over 62,000 National Guard personnel were activated.
Across more than 30 states.
On a note of lasting recognition, the location of the murder itself was officially designated George Perry Floyd Jr. Place.
And beyond local memorials, the crucial role of the public in documenting the tragedy was recognized globally. Darnella Frazier, who was just 17 when she filmed the restraint, received the 2020 Pay and Benenson Courage Award.
And a special citation from the Pulitzer Prize Committee.
Yes, in 2021. The recognition underlined the critical importance of citizen witnesses and accountability in the digital age.
The systemic impact was also rapid. Policing reforms followed the public outrage.
Within a year, at least 17 state legislatures banned or restricted the use of chokeholds and neck restraints. A clear legislative response. And several states took steps toward transparency by making police disciplinary records public.
And finally, there's the sweeping U.S. Department of Justice investigation into the MPD itself.
The DOJ's June 2023 report was damning. It concluded that the MPD operated with a systemic pattern and practice of civil rights violations. This wasn't just about one bad officer. The failure was institutional.
What specifically did the DOJ find?
The findings were comprehensive. The MPD systematically used deadly and excessive force, disproportionately stopped and searched Black and Native American people, violated the free speech rights of protesters, and discriminated against people with behavioral health disabilities. It was a complete breakdown of constitutional policing standards.
The ultimate result of this federal review demands significant enforceable change.
Yes. Minneapolis agreed in principle to negotiate a court-enforced consent decree with the DOJ. This process involves independent oversight and mandated, sweeping changes to everything from training and accountability to recruitment, all aimed at eradicating those systemic failures.
Our analytical review of the sources confirms a precise chronological chain of events that led to a dual prosecution strategy, culminating in unprecedented accountability for all 4 officers involved, alongside a major civil settlement and deep institutional introspection.
Given the detailed documentation that officers ignored warnings, failed to administer aid, and actively prevented bystanders from intervening, the core legal insight is found in those federal convictions. They were achieved not just for the crime of murder, but for the constitutional crime of indifference. And that standard holding officers accountable for willfully failing to act when life-saving intervention is possible raises a powerful question about whether this specific approach to accountability is now the most enduring and effective lever for forcing systemic change across law enforcement institutions nationwide.
Thanks for listening.